You guys ready? I'm all about punctuality. And I can give you 10 more seconds if you want, but I figure we go ahead and kick it off. Everybody ready? All right. Good morning, and it is absolutely great to see everyone here today. This legislative hearing is a subcommittee on disability assistance and memorial affairs, and will now come to order. I want to first welcome all the new members of the subcommittee and all of those returning. I also ask unanimous consent that Congressman Bergman and Congressman Levine will be allowed to sit on the dais, make a statement, and ask questions. Hearing no objections, so ordered. The House Committee on Veterans Affairs has a reputation for operating in a bipartisan manner. I am looking forward to working with Ranking Member Pappas to ensure that this extends to our subcommittee. Turning to today's hearing, we are here to discuss the 8 bills that are intended to benefit veterans and their families. These bills would remove barriers to survivors' benefits for spouses after the loss of their loved one, improve outreach and access to VA services for rural and underserved veterans, impose penalties on predatory actors attempting to take advantage of veterans and their benefits, and help address backlogs on the Board of Veterans Appeals and the Court of Appeals for Veterans Claims. I am honored to have introduced 2 of these bills myself, H.R. 1529 and H.R. 1530, which I will speak about later. Again, thank you for being here today. I now acknowledge I know my colleagues have worked hard on their proposals, and I welcome a healthy discussion about their merits. I now yield to Ranking Member Pappas for his opening remarks.
Well, thank you very much, Mr. Chairman. Congratulations on taking the gavel, and I want to join you in welcoming everyone to the first hearing of the Disability Assistance and Memorial Affairs Subcommittee for the 118th Congress. And before I get started, I want to recognize and thank all of our veterans, but today especially our Vietnam veterans and their families for their service and sacrifices. Today marks National Vietnam War Veterans Day. It's a stark reminder that there's still much more we need to do to help our veterans and their survivors. So as the ranking member of this subcommittee, I look forward to working with you, Mr. Chairman, to advance the cause of supporting our veterans, their survivors, dependents, and families, and holding VA accountable to those that they serve. Well, I'm sure we have policy disagreements from time to time. I'm confident that those disagreements will never be personal. And at the end of the day, I know we are both trying to achieve the same goal, which is to ensure that our veterans and their families have access to the benefits that they've earned through their service. To that end, I appreciate you holding this hearing today. We'll have several important measures to help improve the experience of veterans, their survivors, and dependents when trying to access their well-earned benefits at VA, including my bipartisan Guard VA Benefits Act, H.R. 1139, which I will address later. Congressman Levin has also offered a bipartisan bill on today's agenda to authorize grants to states to improve outreach to veterans, assist with VA claims, hire additional county veteran service officers, or CVSOs, and train them for VA accreditation. And I want to thank Congressman Levin for inviting me to help introduce this important legislation. And Chairman Luttrell, your Veterans Compensation Cost of Living Adjustment Act of 2023 will increase the rates of compensation for veterans with service-connected disabilities and the rates of dependency and indemnity compensation for the survivors of certain disabled veterans. And I appreciate the opportunity to co-lead this legislation and to support you in those efforts. So there are, of course, many other bills on the agenda today, and I look forward to the testimony that we will hear on all of them. And I hope it will provide this subcommittee with valuable information to approve upon the legislation before us and help us provide needed services to our nation's veterans and their survivors. With that, I yield back.
Thank you, Mr. Pappas. We have a full agenda today, so I will ask that everyone holds their comments to 3 minutes, including myself. This morning, we are joined by several of our colleagues, both on and off the committee. We are going to be testifying about the bills that they have sponsored. Ranking Member Pappas, Representative Sismani from Arizona, Representative Levine from California, Representative Self from Texas, Representative Bergman from Michigan, and Representative Walsh, who will not be here today, but we will submit that for the record. I now recognize myself for 6 minutes, even though I said 3, but I have 2 bills. Just to clarify that. I'm proud to have introduced H.R. 1529 and 1530. I also want to thank Ranking Member Pappas for being a co-lead on those bills. H.R. 1529, the Veterans Compensation Cost of Living Adjustment Act, would give a cost of living adjustment to veterans and survivors receiving certain VA benefits. This increase would be the same as Social Security recipients receive and would help veterans keep up with inflation. This legislation is absolutely vital in the face of rampant inflation and a potential recession. We must ensure that our veterans are able to pay their bills and put food on the table for their families. The other bill, 1530, the Veterans Benefits Improvement Act, would help identify and remove barriers that prevent veterans from accessing the disability benefits they have earned. The bill would make several improvements to the disability exam process by ensuring that public-facing disability benefits questionnaires, which are standard forms VA used to assess the veteran's disability rating, are up to date on the VA's website. Making travel payment reimbursements more accessible for overseas veterans that attend a disability exam, and enhancing communications on the scheduling of an exam between contract examiners, veterans, and the veterans' representatives to help prevent veterans from missing their appointments. Moreover, 1530 would mandate a VA report on the feasibility and technical limitations of providing governmental VSOs increased access to VA systems. Governmental VSOs, known as county or tribal VSOs, assist veterans with their claims locally. These VSOs have urged VA to provide them with enhanced access to VA's claims processing systems to better help veteran claims. This report would help us find a path forward on these issues. I look forward to working with Chairman Bost and my colleagues on this subcommittee to advance these bills. I also appreciate the feedback from VSOs who have joined us today. I yield back and now recognize Ranking Member Pappas for 3 minutes for his testimony on H.R. 1139, the Guard VA Benefits Act.
Well, thank you very much, Mr. Chairman, and I look forward to sharing with everyone what this bill does and what it doesn't do. And Mr. Chairman, you've heard me and others on the committee and the VSOs that testified in our joint hearings about the troubling increase of unaccredited claims consultants looking to profit from veterans' disability claims. They peddle a for-profit model for services that veterans can receive free of charge from veteran service organizations like those testifying today. It's alarming because the more third parties that have a hand on a veteran's claim, the greater potential for fraud and abuse, which I'm sure you'll agree we must prevent. So to provide veterans with qualified and competent help and protect them from individuals who may be targeting their benefits, VA has long operated an accreditation, discipline, and fees program to provide oversight of those who assist with claims preparation. Critically, this program also dictates fee agreements between veterans and their representatives when a veteran can be charged and for how much to ensure that the veteran is being charged a fair price. Under current federal law, VA-accredited representatives are the only individuals authorized to prepare, present, or prosecute VA claims on a veteran's behalf. Unfortunately, in 2006, Congress decided to strip the VA of its ability to penalize those who violate the longstanding prohibitions on preparation, presentation, and prosecution of a claim before VA. Let me be clear, what Congress did in 2006 was to remove the penalty for violation of law. It did not remove the underlying criminal acts from statute, meaning it has always been and will be against the law to assist in the preparation, presentation, and prosecution of a VA claim without accreditation. Since then, the claims consulting companies have exploited this dangerous loophole to rake in millions of dollars from veterans across the country. So my bill, the Guard VA Benefits Act, will simply reinstate criminal penalties for unaccredited claims representatives. It does not create new criminal acts, nor does it change the well-established definitions of preparation, presentation, and prosecution. To that point, I want to be absolutely clear on one thing. The gathering and/or development of third-party medical evidence has long been excluded from the definitions of preparation, presentation, and prosecution. The GUARD Act does not change that dynamic, nor would I propose to. I also want to address another argument that some have raised, and that is that the GUARD Act will somehow limit the choices that veterans have to help with their claim. Some companies have even hired expensive lobbyists and lawyers to argue that this bill would violate a veteran's First Amendment rights. Nothing could be further from the truth. This legislation does not ban a veteran from choosing whoever they want when seeking help with their VA claim. If veterans want options, they can talk to any number of professional, well-trained veteran service officers. They can seek help from VSOs like the VFW, the American Legion, and others. And if veterans want a paid option, they are free to turn to agents and attorneys for help. The difference is all of these individuals are accredited and subject to the oversight of VA and OGC. And it's exactly that oversight that for-profit claims consulting companies are trying to avoid. So what these unaccredited claims consulting companies are doing is illegal, and they know it, which is why they've spent tens of thousands of dollars lobbying against this bill. They also know that there's nothing stripping them from becoming accredited today, except as they will admit, they can't make any money. So regarding this legally dubious First Amendment argument, it's long been true in both statute and legal precedent that the government has a special responsibility to develop standards for licensed professions, and that enforcement of those standards of professional conduct is not an abridgment of free speech. For example, federal and state governments provide attorneys with medical providers with accreditation. And it's also true that the government can criminalize unauthorized professional conduct in order to ensure compliance and to protect the public. So there's abundant case law to support both of those premises, which can be found easily. So I'm left to believe that those peddling this argument are simply either grasping at straws in order to distract from the real issue and soften the bipartisan support that this bill already enjoys. It demonstrates clearly the lengths these companies will go to and the money they will spend in an attempt to try to avoid accountability. So the reality is, Mr. Chairman, they exist solely to exploit a loophole in the law and make money off of our veterans, and that's something we just shouldn't support. I hope my colleagues agree, and I yield back.
Thank you, Ranking Member Pappas. The chair yields to Congressman Sismani. You're now recognized for 3 minutes to speak on H.R. 1378, the Veterans Appeals Backlog Improvement Act.
Thank you, Chairman Luttrell, and our fellow members of the subcommittee. I'm grateful that my bill, H.R. 1378, the Veterans Appeals Backlog Improvement Act, is being considered today. This bipartisan effort, which I introduced with Congressman McGarvey, is aimed at reducing wait times for our veterans with claims in front of the Board of Veterans Appeals. In order to expedite claim times and serve our veterans more efficiently, the Veterans Appeals Backlog Improvement Act was created an internship program for law students at the Board of Veterans Appeals. Additionally, this bill would create a 9-year pilot honors program at the VA for recruiting entry-level attorneys to work at the Board of Veterans Appeals. The backlog and delays in claims have been one of the top issues I have heard from constituents and our men and women who served our country. While progress has been made to adjudicate older legacy VA appeals from veterans, the backlog is only increasing with newer claims stemming from the PACT Act. Simply put, the Board of Veterans Appeals does not have enough staff to process the volume of the cases. The backlog of pending appeals has increased in recent years, topping 200,000 undecided cases, with the average veteran facing a wait time of 440 days before a decision. And sadly, there's a heartbreaking story of a veteran in need behind each of these numbers. Last year, there was a report of the Army, of an Army veteran in my home state of Arizona who waited 5 years to simply be heard in front of the Board of Veterans Appeals. He was described as beaten down by a broken system, saying, "I hope I just go to sleep and don't wake up. I am tired of my life being this way and the way it is." Our veterans who were injured in the line of duty, who sacrificed their health and well-being for our country, should feel supported and uplifted by the country they gave so much for, not beaten down. By providing the VA and the Board of Veterans Appeals with tools to better recruit lawyers, we will expedite the process of these claims and eventually cut down on this tremendous backlog. For some of our veterans, that means quicker, easier access to life-changing care. For others, it simply means a better sense of being taken care of by a country that they sacrificed so much for. I am proud to have partnered with Congressman McGarvey on this common sense legislation, and I look forward to working with my colleagues to develop solutions for these brave men and women. Mr. Chair, I yield back. Thank you.
Thank you, Congressman Sismani. The chair recognizes Congressman Levine. You're now recognized for 3 minutes to speak on H.R. 984, the Commitment to the Veteran Support and Outreach Act.
Thank you, Chairman Luttrell. Thank you, Ranking Member Pappas. Thanks so much for including H.R. 984, the Commitment to Veteran Support and Outreach Act, also known as the CVSO Act, in today's legislative hearing. I reintroduced this bipartisan bicameral bill last month with Ranking Member Pappas and Representatives McMorris, Rogers, and Finstad to improve veterans' ability to use their benefits by authorizing VA to award competitive grants to expand the work of county veteran service officers, also known as CVSOs. CVSOs are local county employees who are nationally accredited by VA to prepare, present, and prosecute VA claims. They work with veterans every day and are often the first to inform them about their eligibility for VA programs and services. They also help enroll veterans into the Veterans Health Administration and provide assistance on a range of benefits, including service-connected disability compensation, VA home loans, education benefits, and job placement assistance. CVSOs will be able to use this grant funding to improve outreach to veterans, enhance the development and submittal of claims on behalf of veterans, hire additional staff, and to obtain VA accreditation. In doing so, this program will strengthen economic supports, improve access to care, and enhance connectedness, key strategies that reduce risk and promote protective factors for suicide. We have a responsibility to ensure that veterans and their families can readily access the benefits and services that they've earned, and the CVSO Act does just that. That's why this bill has earned support from a wide variety of stakeholders. This is a long list, including the Department of Veterans Affairs, the National Association of County Veteran Service Officers, the National Association of Counties, National Association of State Departments of Veterans Affairs, Disabled American Veterans, the American Legion, Veterans of Foreign Wars, United Steelworkers, Wounded Warrior Project, Military Officers Association of America, the Association of Mature American Citizens, America's Warrior Partnership, Green Beret Foundation, Military Veterans Advocacy, Fleet Reserve Association, and I saved the best for last, the San Diego Military Advisory Council, the County of San Diego, and several other counties and state CVSO associations. The CVSO Act passed the House with overwhelming support in December, but ran out of time to be considered in the Senate before the end of the 117th Congress. So in the 118th Congress, we're moving the bill right out of the gate. The Senate Veterans Affairs Committee has already reported the bill favorably, and I want to thank Chairman Luttrell and Ranking Member Pappas again for including it in the subcommittee's first legislative hearing. I look forward to working with you to get this bill to the President's desk as soon as possible. Thank you, and I yield back.
Thank you, Congressman Levine. The chair recognizes Congressman Self for 3 minutes to speak on H.R. 1329.
Thank you, Chairman Luttrell. H.R. 1329 enacts legislation that will increase the number of permanent judges on the United States Court of Appeals for Veterans Claims from 7 to 9 and increase the total number of judges from 9 to 11. For decades, the Board of Veterans' Appeals has been criticized in providing timely decisions to veterans who appeal their cases. If a veteran disagrees with the Board's decision, they can expect to wait even longer for their case to be decided by the court. To make matters worse, we anticipate the case load increasing because of the implementation of the PAC Act. Since the court's expansion from 5 to 7 permanent judges in 2011, appeals that have been filed to the court have more than doubled, growing from 3,900 plus in FY 2011 to 8,900 in FY 2020. Increasing the number of judges will provide the court with an opportunity to prevent a backlog and provide veterans with decisions in a timely manner. This legislation is endorsed by the court itself, and Congress even recognized the need by appropriating last year, and now we are authorizing. Because of their sacrifice and their service, Americans' veterans deserve to rest assured that when returning home from fighting battles overseas, they will not be stuck fighting battles with bureaucrats in Washington, D.C. You may be aware that CBO has scored a spending increase for this. I assure you we will find the offset for it to try to corral the out-of-control spending. And for our number 2 panel, I will be asking questions about the tremendous reversal, remanded, redacted, and dismissed rate from the board itself and the role that the board plays in this tremendous backlog. Thank you. I yield back, Mr. Chairman.
Thank you, Congressman Self. The chair now recognizes Congressman Bergman. You're now recognized for 3 minutes.
Thank you, Mr. Chairman. Gerald Jerry Elliott was a U.S. Army veteran and a resident of Kingsford in the Upper Peninsula of Michigan in the middle of my district. A lifelong Uper, Jerry was a member of American Legion Post 363 and an active volunteer with the UP Honor Flight and at the Iron Mountain VA Hospital. After receiving a cancer diagnosis in 2019, he was admitted to the Iron Mountain VA for care. As the disease progressed and he was placed in hospice care, he decided to go home to live out his final days in some level of positivity with his family. Following his death, Jerry's family discovered that even though he received hospice care through the VA, the fact that he received these benefits at home meant his family did not qualify for burial benefits after his death. Under current law, VA hospice care provided at home does not qualify as a death under VA care and is therefore not covered under the non-service-connected burial and plot benefit. As a result, if a veteran with a terminal illness wants the full burial benefit, they would be forced to die in a hospital or nursing home through VA instead of transferring to home hospice care to be with their loved ones. This injustice is unacceptable. No veteran or their family should have to worry about losing VA benefits for their family when choosing to spend their last days in the comfort of their loved ones in their own home. H.R. 234 will address this by extending VA burial allowance eligibility to veterans whose deaths occur at home while receiving VA hospice care if they were previously receiving VA hospital or nursing home care. I thank the subcommittee for the opportunity to testify on behalf of Gerald and his family, as well as the thousands of other veterans and their family members being denied benefits due to this legislative oversight. I'm looking forward to working with the committee to advance Gerald's law and ensure that this injustice is permanently corrected. Thank you, and I yield back.
Thank you, Congressman Bergman. As is our practice, we will forego a round of questioning for the members. Any questions may be submitted for the record. You are now excused, although I do understand many of you are staying to ask questions during the next panel. I now invite our second panel. Joining us today from the Department of Veterans Affairs is Ms. Cheryl Rawls, Executive Director of Outreach, Transition, and Economic Development with the Veterans Benefits Administration. Mr. Kevin Friel, did I pronounce that correctly, sir?
Yes, sir.
Thank you. Deputy Director of Pensions and Fiduciary Services with the Veterans Benefits Administrations, and Ms. Krista Schreiber, Deputy Chief Counsel for the Benefits Law Group with the Office of General Counsel. Will all witnesses please stand and raise your right hand? Do you solemnly swear that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth? So help you God. You may be seated. Thank you, and let the record reflect that all witnesses answered in the affirmative. Ms. Rawls, you are now recognized for 5 minutes to present the department's testimony.
Thank you very much. Good morning, Chairman Luttrell, Ranking Member Pappas, and other members of the subcommittee. Thank you for inviting us here today to testify on views of several bills that would affect the VA programs and services. Joining me today, as you mentioned, is Krista Schreiber, Deputy Chief Counsel for Veterans Affairs, Office of General Counsel, and Mr. Kevin Friel, Deputy Director for Pension and Fiduciary Service at the Veterans Benefits Administration. VA is grateful for your commitment to support our nation's veterans, their families, caregivers, and survivors. While VA views on all bills are detailed in my written testimony, I would like to highlight a few areas related to the proposed legislation. VA supports H.R. 234, Gerald's Law, with an identified funding offset if amended. VA supports the section of the bill extending eligibility for VA burial allowance to a new demographic of veterans and the intent for the effective date. VA understands the effective date would be January the 5th, 2023. However, we would recommend the effective date be 6 months following the passage of the bill. This additional time will allow VA to update necessary forms and systems. While VA has no objection to H.R. 1530, Veterans Benefits Improvement Act, we note potential ambiguity in as it refers to outreach concerning contact information for contractors. It is unclear whether the bill is concerned with informing veterans of the contact information for the exam contractor or with informing veterans that VA may provide veterans' contact information to the contractors. Clarification of the intent would be helpful. VA has concerns with H.R. 854, Gold Star Spouse Equity Act. We support the intended purpose of the bill in expanding benefits for surviving spouses of members of the armed forces who die in the line of duty, subject to availability of appropriations. However, the language does not limit the expansion of dependent and indemnity compensation, DIC, benefits under 38 U.S.C. 1311 for surviving spouses who remarry to situations where the veteran died in the line of duty. The language as currently written would be more expansive than the intent of the bill. Additionally, there are 2 statutes that provide for the granting of DIC benefits, and as currently written, this proposed bill would only address one of those statutes, creating disparity in the DIC benefits program. VA respectfully requests clarification on the intent of this bill, and additionally, we defer Section 2 of the bill to the Department of Defense, as it would be responsible for implementation. VA does not support H.R. 1378, Veterans Appeal Backlog Improvement Act, because the program as described in the bill are duplicative of existing and well-established entry-level attorney hiring initiatives and temporary law clerk appointment processes. If required, the competitive honors program may negatively impact participation in and outcomes of the board's existing law clerk program. VA supports H.R. 1529, Veterans Compensation Cost of Living Act of 2023. Annual cost of living adjustments to compensation rates tangibly express this nation's gratitude and respect for the sacrifices made by service-disabled veterans, their surviving spouses, and children. This bill would authorize VA to make cost of living adjustments in accordance with past legislatively authorized practice and in accordance with the established expectation of veterans and beneficiaries. VA supports H.R. 984, Commitment to Veteran Support and Outreach Act, providing the availability of appropriations. VA values the partnership it has with the veteran service organizations, including the county veteran service officers and the tribal service officers who are affiliated with us, and we continue to look for ways and opportunities to further engage with them. Chairman Luttrell, Ranking Member Pappas, and members of the subcommittee, this concludes my statement, and we will be happy to answer any questions you or the subcommittee may have.
Thank you, Ms. Rawls. Ms. Schreiber, I was disappointed to see that the VA does not support H.R. 1378, the Veterans Appeals Backlog Improvement Act, as currently drafted. I commonly hear from veterans as well as staff who are frustrated the VA is taking years to decide their Board of Appeals. Why does the board not support establishing a program to provide mentorship opportunities from seasoned attorneys to hire, which may help improve training and quality decisions?
Good morning. So first I want to say, we appreciate the interest in the number of claims that are with the Board of Veterans Appeals. And currently, and we want to say thank you also for resourcing the Board of Veterans Appeals. Last year, there was a large focus on hiring veteran law judges, and this year there's focus on hiring attorneys to fill the drafting of those decisions. In a recent hiring, there was about 1,700 eligible applicants that are being looked at currently, and there's expectation that the hiring or the amount of attorneys at the board will increase by 25% this year. We think that will go a long way in helping reduce the number of claims.
Yes, ma'am, but my question is, why is the VA opposed to the bill?
The VA is opposed to the bill because we currently have a system in place for hiring entry-level attorneys, and this could go ahead and frustrate that purpose, and we want to get people writing decisions as quickly as possible, and it's currently an effective process.
I would disagree that it's an effective process, given the narrative of what's happening in the appeals board. So my question again is, why is the VA opposed to an enhanced bill that would increase the capabilities of the board in processing the appeals?
VA believes that a better use of the resources that we have now would be to hire attorneys into our attorney positions and train them as attorneys under the veteran law judges.
That didn't really answer my question. And this is one of those questions that I need clarification on, given the gravity of what is happening with the veteran community and the appeals board. So instead of me just continuing to dig in on this one, I'm going to move into my second question. Just know that I'll probably be requesting another meeting with you.
That's perfectly good. The board, I'm with the Office of General Counsel, and I'm filling in for the board right now, but the board did indicate that their leadership is more than willing to meet with Congress.
Who would I normally be speaking with in front of this committee if it's not you? Do you have a name for me?
No, I don't have a name for you.
My second question, so Social Security Administration supports allowing representation at the initial claim stage because SSA believes qualified representations on the front end may reduce the number of appeals. Would the VA support allowing accredited representations to charge a reasonable fee at the initial claim stage similar to SSA?
That's a very interesting question. I can tell you in the past, VA has shaped its view on this issue based on Congress's intent to keep the system non-adversarial and ensuring that the money and the benefits that go to veteran isn't unnecessarily reduced by the fees that would go to attorneys and agents. I can't really provide a definitive position from VA at this point on that because that hasn't been necessarily considered, but I'm happy to take that question back for an official position.
Please do.
Will do.
And Ms. Rawls, please expand on the VA's suggestions to improve my bill, H.R. 1530, the Veterans Benefits Improvement Act.
Thank you very much for the question. We think that the way that it is written, we would need to work through the types of communications that we're going to put out to our veterans and the types of communication that will go out to the contractors. So that way they will know what is expected of them. Based on this, we certainly will make ourselves available for any subsequent conversations to this. But we just need that language to be very, very clear to cite those expectations, sir.
Okay. Thank you. I yield and recognize Ranking Member Pappas.
Thanks, Mr. Chairman. Ms. Schreiber, if I could ask you a few questions about the Guard VA Benefits Act. One of the consistent and false rumors regarding the act is that somehow providers of third-party medical evidence might be swept into the net. And I understand the concern of some medical evidence providers, but I feel it's unwarranted. Could you clarify for the subcommittee, has the provision of medical documentation to veterans ever been considered to be part of the definitions of preparation, presentation, and prosecution? And is there anything in the Guard Act that you feel would change that dynamic?
We do not consider the submission of medical evidence to be part of preparation, presentation, and prosecution of a benefit claim. Medical evidence is created as part of almost seen as expert testimony versus a claims preparer or an attorney, agent, or VSO representative is an advocate on the veteran's behalf. They're two separate roles, and they both play an important part in our VA system, but they are separate and distinct.
Okay. And nothing that you see in the bill would change that dynamic?
Nothing in the bill would change that dynamic.
Now, I've heard a criticism that the Accreditation, Discipline, and Fees program doesn't adequately define preparation, presentation, and prosecution so that the activities that are prohibited under law aren't clear. Can you explain to the subcommittee how you all define preparation, presentation, and prosecution for purposes of the ADF program, and how long have those definitions been in place?
We are currently considering adding a definition to our regulations on the practice before VA, which would include the preparation, presentation, and prosecution of a claim. It would include advising on a claim, preparing a claim, and filling out the documents necessary for a claim. It would also include submitting a claim to VA, presenting the claim, and representing on the claim, prosecuting the claim before the agency. We currently do not have an official definition, but we do have something on our website, and I'm going to say, and if we don't, we will soon, that will clarify that in an FAQ.
Okay. Well, we'll look for that information, and maybe we can stay in touch on that, but it's the intent of the bill not to change those definitions themselves. And I'm just wondering, regarding the Accreditation, Discipline, and Fees program, one of the chief benefits of the system is the oversight of and insight into the activities of those who are helping veterans with their disability claims. That sort of transparency is sorely lacking with the for-profit claims consulting industry. So I'm wondering, how would the Guard Act enable you all to better protect veterans through ensuring training of service providers and the oversight of fee agreements?
What the GUARD Act would allow a penalty, a single standard, a national penalty that could be imposed on individuals who charge our veterans and who are not accredited and are not doing so within the VA system. It's important to know that within the accreditation system, there are safeguards in place that allow us to take action if a veteran is harmed or may potentially be harmed. A veteran's allowed to inform us of any misconduct or potential incompetence on a claim, and we can look into that matter. In addition, if a veteran believes that they have been charged an unreasonable fee, they can motion the Office of General Counsel. We can look at that fee, and we can go ahead and reduce the amount that is being paid to, or is being charged to the veteran if necessary. Last year, we returned $2.5 million to veterans in unreasonable fees.
Thanks for those comments. And just zeroing in a little bit on the training, one complaint that we've heard again and again from the for-profit companies is that ADF is meaningless because the training doesn't keep up with current law. So can you tell us what your office is doing to proactively update the ADF program to ensure that agents, attorneys, and service officers have the best training possible?
There are a few things that we're doing. One, we're looking at increasing our continuing legal education requirement. It's currently at 3 hours within the first 12 months, and then 3 hours every other year. We're looking at increasing that number. In addition, all of our accredited individuals who have access to the VA Veterans Benefit online system where they can access the claims files also take a different type of training known as TRIP training that also gives information on the VA system.
Well, thank you for that background and for VA's support of this legislation. I yield back my time.
Thank you.
Thank you, Rick. Thank you, Ranking Member Pappas. Congressman Crane, you're recognized for 5 minutes.
Thank you, Mr. Chairman. Ms. Schreiber, can you please give the committee an example of exactly what type of issues issues veterans are being exploited in the legislation just described? With the GUARD Act.
So one of the things that the GUARD Act is looking to penalize is individuals who are assisting veterans outside of the VA realm and are not subjecting themselves to the VA safeguards of this system. And this means that when a veteran has a complaint or has a disagreement with the individual who may have unlawfully helped them on their VA benefit claim, there's no one for them to report it to. Our resource and our recourse there has been to inform the individual that they are doing something contrary to law, and then work with our partners, either federal enforcement agencies or state agencies, to see if there are state laws or consumer protection laws that they may have violated. But there's no direct link between doing what our law says is wrong and a punishment.
Okay, thank you. Ms. Rawls, how will VA ensure that grants authorized in the HR 984 Commitment to Veteran Support and Outreach Act are reaching Native American veterans who often are underutilized VA benefits and services?
Thank you very much for that question. As you know, we currently have over 500, actually close to 580 recognized tribes, 38 tribal veteran service officers that are accredited. We continue to work with our county veteran service officers as well as NASDVA and the National County of Veteran Service Officers Association. One of the items that we will certainly have to do is to, one, implement appropriate comms around it. We will need to ensure that we're structuring to get that information out from our lowest levels to include our 56 regional office directors that are located around. We'll have to integrate this again with our leadership that is out there working with our other veteran service officers and our state Department of Veterans Affairs. And mostly, because I am in outreach, it would have to be cyclic, continuing to ensure that this information is provided on a continuum so people understand and we can reach them. There is also the new tribal service committee that has just recently been stood up, and I think they will be a great place for us to also work through getting that information out.
Do you have direct communication with them, ma'am?
I frequently am asked to come and brief and talk about what VA is doing, and so we do get invited to attend those meetings.
Okay.
Yes, sir.
Thank you. Mr. Friel, for HR 234, Gerald's Law Act, would support the survivors of veterans receiving VA hospice care at home by allowing them to remain eligible for burial allowance. How many survivors would this bill potentially impact?
Thank you for the question, sir. We're currently working with our data people to try to extract that because there's, although VHA has a number, one of the things that we have to make a clarification on is, if they were in receipt of compensation or pension at the time of death, they would have been entitled to the benefit regardless of where they passed away at. But we're trying, so we have to distinguish between those individuals and individuals who may not have been entitled at the time.
Okay, so you don't have really even a ballpark at this point?
The number that we saw from BHA was somewhere at about 60,000 per year.
60,000?
A little higher than that. But as I said, we have to disseminate between those who would have been entitled to the benefit anyway, as opposed to those who were not.
Thank you, sir. I yield back my time.
Thank you, Mr. Crane. Congressman Ramirez, you're recognized for 5 minutes. Congresswoman, I apologize.
Thank you. Appreciate that.
Sorry.
That's okay. Thank you, Chairman. Ms. Rawls, one of the chief marketing claims that for-profit claim consultants say is that somehow veterans will receive resolution on their claim faster by using their services. But looking at our info here, the average turnaround time between a fully developed claim and a non-fully developed claim differs by only about 9 days as of March 25th of this year. Coupled with the fact that the VA's duty to assist helps veterans ensure their application is complete and it contains the correct evidence, it seems to me that veterans are risking an awful lot by using unaccredited, unaccountable, for-profit organizations. So Ms. Rawls, can you tell me, does the VA see any material difference in claims submitted with the assistance of a VSO versus those submitted with the assistance of a for-profit company? And I would say the second part of that, if you could answer as well, is what are the dangers to veterans using these claim consulting companies?
Thank you very much for that question, ma'am. I will tell you, I don't know that we see any difference because those not-for-profit companies are just as aware of our processing systems in what we use to adjudicate a claim. But I will put this caveat out there. We have not studied that to see if there are differences between an accredited veteran service officer or an accredited for-profit individual. So I just want to make that clear. As to why a veteran would work with an individual for their claims, it's just that this process of claims processing is very, very convoluted, and the laws that are out there for everyone to comprehend is sometimes very difficult. I myself, as being a veteran, and my father's a veteran, it was very difficult to help him understand a lot of the things that were going on. And it dawned on me that he would probably rather hear that from someone else besides me. And so we continued to work to get him the assistance that he needed to file that claim. And Krista, I don't know if you wanted to add anything to that?
Sure. I will just tag on a little bit there and wanted to let you know that there's really no way for us to track these unaccredited companies within our system. When we're talking about tracking accredited individuals, they each have a POA code, and we associate that with the veteran. And so we can, at any given time, we can go ahead and we could pull the entire client list for any of our veteran service organizations, our attorneys, our agents. We wouldn't be able to have that same access to who they have helped, and a lot of the times it's helping behind the scenes, and then they're trying to return the responsibility back over to the veteran themselves in order to file the claim and certify that it's all true and correct.
So let me just ask you, because just hearing you, I go back to being a caseworker many, many years ago and thinking of the advocacy work on behalf of the veteran. How many claim consultants do we have now, for-profit claim consultants, you would say at this point? Is there a way for you to have a number on that?
We don't have a number on that.
And so you're saying that as of right now, because of the way that the system is, for those that are unaccredited, you have no way of being able to track if they are misleading or providing wrong information to a veteran as they're trying to file their claim, because you have no direct connection with them. Is that correct?
Correct. And the only way for us to find out that information would be, for example, through the FTC's database system where they can submit complaints. It would be through complaints that come in directly to our office and through the IG's office.
And you haven't seen complaints at this moment that have come in directly in the last few months?
We have, yes.
And what would you say the rate of complaints is?
I don't have a rate for you, but I can tell you
Number.
in our office, well, actually, maybe I do. About 40% of the complaints that we receive in our office this past year were about unaccredited individuals.
I figured the number would be up there. So I just, I'm wrapping up on time, but I just want to say it's really important for us to identify ways to ensure that our veterans are getting the service they need for their claims and they're not getting cheated on by consultants that they feel they have to bring on board just to be able to process them. I yield back.
Thank you, Congresswoman Ramirez. Congressman Self, you're recognized for 5 minutes.
Thank you, Chairman. First of all, as the county judge, county executive of a county of 1 million people, I want to just emphasize how important the county VSOs are. They are the people on the ground, and I recommend that you keep them as qualified and staffed as you can. Now, I want to discuss the board versus the Court of Appeals. The board is under VA. The Court of Appeals is U.S. Judiciary. We have, when I look at the stats on your last report, 60% of the single judge cases, this is for you, Ms. Schreiber, were either reversed, vacated, remanded, or dismissed, which indicates to me that there is a problem with the board that is causing me to have to file the bill to increase the number of judges at the Court of Appeals. So do you believe that there's an issue with the quality of the board members that are leading to this increase in cases that are reversed, vacated, remanded, or dismissed?
I'm going to have to go ahead and take this question back to the board. This isn't something that we had discussed, but I'm happy to get you an answer on that.
So you cannot explain why so many of these are remanded or JMR'd?
No, I cannot.
Okay. Do you collect data on the errors that are in the board's decisions?
Again, I can take this question back to the board, that question as well, and make sure that you get an answer on that.
Okay, I would appreciate it, and I would recommend that when we have this discussion that involves the board, I would ask for a board member or a representative of the board to accompany you to the board. Thank you. Chairman, I yield back.
Thank you, Congressman Self. Congressman McGarvey, you're now recognized for 5 minutes.
Thank you, Mr. Chairman. Appreciate it. Thank you all very much for being here today. Mr. Rawls, I'm going to ask you about H.R. 984, which is the Commitment to Veteran Support and Outreach Act, introduced by my good colleague, Mr. Levin. As you know, this bill would authorize $50 million for competitive grants to expand outreach to our veterans, especially our underserved veterans, which I'm sure is a goal that we can applaud and share. In the testimony, you guys stated that the Veterans Benefits Administration already maintains a robust outreach program. Of course, I think more can always be done, particularly in addressing disparities with our Black veterans, with women veterans, with other underserved groups. While proactive outreach is critical, we want to make sure that the funded outreach from the bill is working. So could you tell us a little bit about how the VA would measure success in outreach with these grants, what metrics you guys would use, what oversight you all would use to see that this is actually working?
Well, thank you very much for that question, and wholeheartedly agree with you that we can never do too much outreach. I actually have oversight of about 8 special emphasis programs in which we have regional office coordinators that connect with the CVSOs as well as the tribal veteran service officers. So we're continuing to strengthen that relationship to include the state in ensuring that we have connecting activities to meet those populations in their spaces and to meet those needs. One of the things that we will certainly need to do with establishing a grant program for, in this instance, would be to develop those metrics that you're talking about, and you know, having an opportunity to be able to be a part of that. I would say we would certainly need to look at the track record of the VSO and them being able to get their training done and be accredited and certified and staying in the good graces. There will also need to be a look to see whether they are assisting individuals, and so we would have to develop some type of mechanism to be able to get some feedback from the individuals that they have helped, and we would have to stratify that out. I mean, we currently have, you know, a number of surveys that we do to collect engagement information as to whether people are trusting us, so we would just have to adapt that. So there will be a number of mechanisms that we would certainly need to put in place to include a robust site visit program, sir. Thank you.
Thank you, and I appreciate that, because it's not just being proper stewards of taxpayer dollars in this instance, it's making sure those taxpayer dollars actually go to helping our veterans and making sure that they are used, that that outreach is happening, that our veterans are getting the services they need. That means that proper implementation, of course, as you all know, is key to making this happen. So look forward to continuing to work with the VA to ensure that any programs funded through this bill actually reach the veterans who most need that care. Last question, Ms. Rawls, what more can the VA do to improve the confidence of our underserved veteran communities that may struggle to trust the VA?
And thank you very much for that question. I kind of touched on it. I'll tell you, I've always been miffed at my father preferring to get information from somebody else besides me who works at the VA. I think that is just a mindset that we have to come to terms with, and to ensure that we are continuing to put information out there that is easily digestible. The time it takes to just review what is necessary to bring to the table, it sometimes, you know, is discouraging to our veterans. I frequently have opportunities to go out and talk to particularly our Black veterans in just trying to regain that trust, because they have been or had a bad experience, and just trying to get them to come back to us. And I always tell them in every outreach event, you have the right to disagree with the VA. If you disagree, then come in. You need to come in. You need to use our 1-800 numbers, and we have to make sure people know we have created these avenues for them to reach us, sir.
I appreciate that, and obviously we all share that goal, and however we can help here, how we can build that trust, that transparency, that openness, that listening to our veterans, what they need, I think is really important. Mr. Chairman, I yield back.
Thank you, Mr. McGarvey. Congressman Bergman, you're now recognized for 5 minutes.
Thank you, Mr. Chairman. Ms. Rawls, Ms. Schreiber, Mr. Friel, thank you for being here, and feel free, any of you, to chime in on answers that may not be specific to your particular position. But as I've listened to the testimony and to the questions being asked, I'm curious. If I was to give you the following three terms, do you see any correlation? Right or freedom to choose, free market, for profit. Do they have any correlation in your mind? That's okay, I don't want to wait too long on it. The point is, what I heard, and if you want to respond in writing afterwards, because of the fact is, I think a significant number of us up here on this dais swore an oath to support and defend the Constitution and to do the right thing. And all of us are on this committee because of the fact we want to do the right thing for the veterans and enable their right to choose, their freedom to choose. And the only way we're going to enable that is to have a free market that in some cases involves companies that work for a profit. Last time I checked, for a company to work for a profit, to enable it to provide jobs for its employees, to provide services for whatever market they're in, that's a good thing, not a negative thing. So I want us to all keep in mind of what that term really means. Ms. Schreiber, does the current system allow for accredited agents to charge a fee for assisting with a veteran's initial filing?
The current system does not allow for charging on an initial claim.
So with that said, does the current system where agents and attorneys charge a percentage of a total amount of past due benefits create a financial incentive to drag out the process as long as possible?
We do not believe it does. Generally, the attorneys and the agents get involved after the initial claim and the initial decision on the claim has been decided, and that's when they enter the process. Typically, before that, veterans often use veteran service organizations or will look to
I know
VA
your answer could eat up a lot of time, just like the process does right now. Would it be better for everyone involved to include the people who work at the VA, the people who are providing the services, whether it's the VSOs, whatever company, the veterans especially? Would it be better for everyone involved if these claims were filed correctly and resolved on the first go-around? Would that be a better scenario? Yes or no? I mean, would it be better to get it right the first time? Now, I was an airline pilot, and I had to get the landing right the first time. Okay, otherwise there wasn't an option there, or other things we've done. But would it be better for all, yes or no, if it was resolved the first time?
Yes,
Thank
we
you.
try to get it right the first time.
Okay, so the point is, what we get into is a situation where we talk about efficiency versus effectiveness. I don't think anybody in this room, no matter who you are, would disagree with the following statement, that we want to have effective outcomes for our veterans, positive outcomes. And sometimes the outcome is not necessarily a positive, it's a rejection. There's sometimes a no for logical reasons. But what I see is that the efficiency is sometimes too often valued over the effectiveness, and now we get into a mix of both, and in the end, the veteran goes, what's happening? Why can't I go to a reputable company to get an outcome that I want in an effective timeline? So, any thoughts on how we become more effective?
I think within the VA system and with the accreditation system that we are effective in that realm and that there are safeguards built in place.
Are we as effective as we could be?
There's always room for improvement.
Bingo. Well, with that case, there's always room for improvement, and we'll talk about that later. Mr. Chairman, I yield back.
Thank you, Mr. Bergman. Congressman DeLuzio, you're now recognized for 5 minutes.
Mr. Chairman, thank you. Good morning. I think we're still morning. Good morning, everyone. Thanks for being here. I want to talk a bit about the PACT Act, and some things that have happened and what you're seeing since the PACT Act was signed into law, and we're now in this important phase of implementation for many generations of veterans, including the one I'm a part of, post 9/11 veterans, who I think we're at this critical moment where we have a chance to have more veterans who are now eligible come into the VA. I know there's been talk, and we'll continue to have talk and work about the outreach efforts to do that. But I want to focus on whether, and Ms. Rawls, this question I'll direct it to you, and if others want to chime in, please do. But since the PACT Act was signed into law, whether the VA has seen an uptick in veterans using non-accredited representatives to file that benefits claim.
Thank you for that question, sir. I'll start out with a few stats. We have seen an increase in receipts of about 28% since the PACT Act.
That's total.
Total receipts,
okay.
Yes, sir. It's been about 28%. Our output has increased, but it's only increased a little over 12% at the same time year to date. With that said, I don't have any information on that. We'll have to take that one back. But we are continuing to put more employees. We're continuing to hire, and we're continuing to make sure our outreach program is integrated with the VSOs and the communities, as well as putting things out from a, I guess the tech world would call it, any outlet that you can use on the modern technology, your telephones. You can tell how old I am. But we are continuing to do that. And so we know we're reaching more people. The information is getting out there. I don't know at this point, and we'll have to take that one back, as to whether they're using more accredited VSOs versus not.
So I'll look forward to finding out what you found there. Thank you. And you started to talk about it, but I want to ask pretty directly, what the VA has been doing to educate veterans on working with accredited rather than non-accredited representatives.
Well, thank you very much for that question. We have been collaborating with our veteran service organizations from the beginning of the PACT Act, getting that information out there, seeking their guidance and help in how to structure some of the communications that have been going out. Recently, we make sure that we're looking in areas that we generally don't look to. We have hosted a number of non-traditional events. I think we were just at the Pentagon last week, ensuring that any individuals knew about the PACT Act, and we'll continue to collaborate with our VSOs. We have events planned probably for the rest of the year and longer, as well as ensuring that our regional offices are working with their local structures. I think the unique thing here is you have this whole layer at the top. We have been really looking to push down the messaging in getting our regional office directors and medical center directors out there holding town halls and talking about the PACT Act, sir.
Good. Well, thank you. I'll look forward to finding out what you find on the accredited versus non-accredited. Thank you for your time. Mr. Chairman, I yield back.
Thank you, Mr. Deluzio. Mr. Pappas, do you have any follow-on questions? Mr. Green, Mr. Self, follow-on questions? Yield to Mr. Green.
I'd like to piggyback off what my colleague, Mr. General Bergman over here, was talking about. And any one of you, feel free to answer this. You guys know what hoops you must jump through to become accredited? We keep talking about accredited. Do you guys know what hoops a consulting firm must jump through to become accredited?
Yes, we don't accredit consulting firms. The only organization that can be recognized by VA we are authorized to recognize organizations that serve veterans, but they must do so free of charge. So there is no mechanism to recognize for-profit organizations. As far as individuals go, we recognize representatives of recognized veteran service organizations. For them to be recognized, they must submit an application. In that application, their certifying official at each organization certifies as to their good character and fitness, and we review that in the Office of General Counsel, and we accredit the individual. With regard to attorneys, we also receive an application, and we heavily rely on their state bar license to establish their good character and reputation. And based on that information, we make a determination for accreditation.
Hold on a second, ma'am. Do you realize that a lot of veterans, if given the choice, like Mr. Bergman was referring to, would often choose to go out in town or not use the VA or use a private business or consulting firm for care?
We do have a third mechanism for accreditation, and that's accreditation as a claims agent. And this is a non-attorney practitioner, which kind of seems to fit with what you're talking about.
Yep.
In order to be accredited as a claims agent, it would once again be the application process. Here, we don't have another entity to kind of to assist us with that application process. So we go ahead and we do our own character and reputation review. We review the business that you are in. We identify potential areas of concern. We do a background check. We check references. And then based on that collective information, we make a determination as to whether you can sit for an exam to test the fitness. And to become accredited as a claims agent, you must achieve a 75% on that exam.
Thank you.
On behalf of the subcommittee, I'd like to personally thank all the veterans and the veteran spouses in the room with us today. Mr. Friels, Ms. Rawls, Mr. Friel, and Ms. Schreiber, thank you for joining us. Thank you for your previous service and your continued service. Representing the Veterans Affairs Department has to be the largest weight that anyone can undergo. I know because I'm a veteran, and I'm sure that we're not easy to deal with. And that being said, since I consider the veterans of our country to be one of our most precious assets, it is our job on these subcommittees and committees to ask the hard questions. Make no mistake, we don't intend to create a fence. We just want to make sure that our veterans are taken care of. So thank you so much for joining us today, and you're now excused. Yeah, I know. We welcome the third panel to the desk, and everyone else can stretch their legs. Good morning, everyone. Ready? And welcome for coming in today, and thank you for being on our third panel. Today, we have Mr. Shane Learman, the Deputy National Legislative Director with the Disabled American Veterans. Mr. Lawrence Montreal. Good enough? I get it? Close or?
I was right on target, sir.
Thank you very much.
First time.
We're working hard on that one. Legislative Director with the American Legion. Ms. Christina Keenan, Deputy Director for National Legislative Service with the Veterans of Foreign Wars of the United States, and retired Army Lieutenant Colonel Bill Taylor, co-founder and Chief Operating Officer of Veterans Guardian VA Claims Consulting. Would you please rise? Please raise your right hand. Do you solemnly swear that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You may be seated. Thank you, and let the record reflect that all witnesses answered in the affirmative. First, we will hear from Mr. Learman. You are recognized for 5 minutes, sir.
Chairman Luttrell, Ranking Member Pappas, and members of the subcommittee. DAV is grateful for the opportunity to appear before you today. Our written testimony covers all of the bills being considered. However, my comments this morning will focus on just a few of these. Mr. Chairman, DAV was founded over 100 years ago by World War I veterans who banded together to assist each other in establishing their claims for earned benefits. Today, DAV is a congressionally chartered and VA-accredited veteran service organization that provides free VA claims and appeals representation to veterans and their families. H.R. 1139, the Guard VA Benefits Act, would impose fines on individuals for soliciting, contracting for, charging, or receiving any unauthorized fee or compensation with respect to the preparation, presentation, or prosecution of any claim for VA benefits. DAV strongly supports the Guard VA Benefits Act, which would reinstate these criminal penalties for those who charge veterans and their families fees for preparing a claim, all the while intentionally skirting around VA accreditation requirements. For many of our nation's disabled veterans, VA disability compensation can be the difference between making ends meet and more severe outcomes such as homelessness. DAV believes that no veteran should pay these entities to file a claim. Veterans have already paid with their service and sacrifice. DAV fully supports H.R. 234, the Gerald's Law Act. It would provide a burial allowance for certain veterans who die at home while in the receipt of hospice care furnished by VA, even though they are discharged from receiving care at a VA medical facility or a long-term care center. Burial benefits should be available to veterans who choose to pass comfortably at home under hospice care with dignity in the comfort of their own homes, surrounded by their family and loved ones. For decades, DAV has called on Congress and VA to support significant and meaningful reforms aimed at addressing the growing backlog of VA claims and appeals processing. Mr. Chairman, I am a VA-accredited DAV benefits advocate, and I've been assisting veterans and their families for 25 years. That includes over 5 years at DAV's National Appeals Office at the Board of Veterans' Appeals. Based on my experience, a key measure to improve the appeals process is to provide the board with adequate resources to better support its judges. By establishing an internship program and authorizing the hiring of entry-level attorneys, the Veterans Appeals Backlog Improvement Act, which DAV strongly supports, would vastly improve the board's ability to hire and retain qualified attorneys to help address the backlog of appeals. Another avenue in improving the timeliness of the appeals process is to permanently increase the number of judges at the Court of Appeals for Veterans Claims. Currently, the court has authorized 7 permanent judges and 2 additional judges as a part of a temporary expansion provision. The court's 2021 annual report indicates that even with the 7 permanent judges and 2 temporary judges, they had to recall 4 retired judges due to the strain of the caseload. Based on the court's own statement, 7 permanent active judges are not adequate. Therefore, DAV does support H.R. 1329, and we agree that the court should continue to have 2 temporary judges along with 9 permanent judges. Finally, Mr. Chairman, we thank you and Ranking Member Pappas for the Veterans Compensation COLA Adjustment Act of 2023. Many service-disabled veterans and their families depend on VA compensation benefits as their sole income. This COLA will benefit them by helping to maintain the value of VA benefits. Without COLAs, many disabled veterans who sacrifice their own health and family life for the good of our nation may not be able to maintain the quality of life they deserve. DAV firmly supports the Veterans Compensation COLA Adjustment Act, and again, we thank you both for introducing this important piece of legislation. Mr. Chairman, this concludes my testimony, and I look forward to any questions you and the subcommittee may have.
Thank you, Mr. Learman. Mr. Montreal, you're now recognized for 5 minutes.
Chairman Luttrell, Ranking Member Pappas, and distinguished members of the subcommittee, on behalf of the 1.6 million veterans and service members of the American Legion, I thank you for the opportunity to testify today. I'll be relatively brief because I understand we're the third panel, but I'd be remiss if I didn't mention in my opening remarks the vote that will take place in the Senate later today that will repeal both the 1991 and 2002 Iraq AUMFs. Decisions of war and peace are among the most important decisions deliberated in the halls of Congress, and many of the bills that we are discussing today are a direct result of the decision to go to war 20 years ago. From caring for Gold Star families who lost their loved ones to streamlining the claims and appeals process for millions of veterans exposed to burn pits, all are the direct result of decisions of war and peace. We are pleased to see the Senate is likely to repeal these AUMFs and give closure to millions of veterans and reaffirm to them that their war is over, and are hopeful the House will move swiftly to do the same. Although wars end, the moral obligation to uphold our promise to those we sent into harm's way and ensure they receive the care and benefits they rightfully deserve has no expiration date. I'd like to thank the members of this subcommittee for their leadership on the litany of issues we will discuss today, and ensuring that we fulfill President Lincoln's promise to care for those who served in our nation's military and for their families, caregivers, and survivors. I would just like to highlight the American Legion's support for the Guard VA Benefits Act and thank Chairman Pappas for his leadership on that bill and on this issue in particular, and reiterate the need to reinstate criminal penalties for unaccredited individuals charging unauthorized fees. Many of these fees are, in our opinion, excessive. They're 400% to 600% of a monthly increase, and on average, by admission of these companies of their own, that's sometimes between $4,000 and $8,000 for service that is provided free of charge by veteran service organizations. In 2021, American Legion service officers insured and secured $14.8 billion in initial claims for veterans, with an average monthly payout of $1,400. In 2022, that was $16 billion. We must ensure that we give VA the tools to protect veterans from being defrauded. Thank you once again for inviting the American Legion to share our position on the bills before us today, and I look forward to the impending discussion.
Thank you, Mr. Montreal. Ms. Keenan, you're now recognized for 5 minutes.
Chairman Luttrell, Ranking Member Pappas, and members of the subcommittee, on behalf of the men and women of the Veterans of Foreign Wars of the United States and its auxiliary, thank you for the opportunity to provide our remarks on legislation pending before the subcommittee. The VFW's views on all the bills can be found in my written testimony. I will take the opportunity to highlight 3. The VFW supports H.R. 1530, the Veterans Benefits Improvement Act, which would require VA to publish all disability benefits questionnaires, or DBQs, on a publicly available VA website. The VFW also recommends that language be added to authorize the use of DBQs in private telehealth appointments. The use of telehealth has expanded significantly since the COVID-19 pandemic, both in the private sector and at VA, becoming a regular practice for modern healthcare. The VFW also supports making improvements to compensation and pension exams by providing more contact information for veterans and their accredited representatives regarding scheduling with VA contractors. It would also require a report on VA's efforts to provide travel reimbursements to veterans living abroad to attend their exams. The VFW supports H.R. 984, the Commitment to Veteran Support and Outreach Act. Though we do have some concerns, the VFW supports efforts to expand outreach to provide benefits to underserved communities, including increasing the number of county and tribal veteran service officers. However, offering more grant money is simply not enough to solve some of the longstanding trust issues, specifically on tribal lands, with outsiders providing claims assistance. The VFW suggests including veteran service organizations as eligible grant recipients to enable them to hire and train representatives specifically from tribal communities to serve their tribal communities, finally reaching this group of underserved veterans. Lastly, the VFW continues to strongly support H.R. 1139, the Governing Unaccredited Representatives Defrauding VA Benefits Act, or the GUARD Act. This legislation would reinstate penalties for charging veterans and their survivors unauthorized fees related to claims for benefits, for VA benefits. Individuals who assist in the preparation, presentation, or prosecution of VA claims must be accredited and adhere to certain standards of conduct, training, and the fee structures provided under the law. We believe that unaccredited claims consultants must be subject to penalties in the same manner as all accredited representatives in order to protect veterans from predatory practices. Some of these companies claim that they provide veterans with more choice and that veterans may not have access to available free services or may have been dissatisfied with the services they've used. To claim that there are not enough free claims representatives is completely untrue. There are VA-accredited state and county service officers, veteran service organizations like the VFW, and numerous state programs where there are a large concentration of veterans, like the Texas Veterans Commission. These companies may also argue that the exorbitant fees they charge in some way make them more effective in assisting veterans. This is patently false. Last year alone, the VFW helped more than 500,000 veterans recoup $11.2 billion in benefits, and not a single dollar went to the VFW. None of these unaccredited companies even come close. There are also claims that the GUARD Act violates First Amendment rights. This is another false narrative. There are many examples in case law that dispute this. Consultants have free speech rights to provide advice. However, the government may, and in this instant does, as it should, require professional advice to ensure minimal competency and accountability. As soon as a consultant charges fees, their advice becomes professional conduct and should be regulated. Accreditation also means oversight by VA's Office of General Counsel. Currently, these predatory companies have no accountability, no oversight, and no penalties. If they were genuine in providing veterans with more choice, they would choose accreditation and offer quality services that are transparent and legal. They refuse to become accredited because the law does not accommodate their business models, meaning they skirt the law because they are profiting from veterans' disability benefits. Companies that prey upon veterans must be held accountable. Chairman Luttrell, Ranking Member Pappas, thank you for the opportunity to provide my remarks. I look forward to answering any questions you may have.
Thank you, Ms. Keenan. Colonel Taylor, you're now recognized for 5 minutes.
Chairman Luttrell, Ranking Member Pappas, members of the committee, thank you for the invitation to be here today. My name is William Taylor, and I am the co-founder of Veterans Guardian VA Claim Consulting and a veteran of the U.S. Army. I am a West Point graduate and retired in 2018 after 23 years as a lieutenant colonel, including 6 operational deployments. I am proud to have served my country and am proud to have co-founded one of the largest veteran-owned and veteran-operated companies helping veterans navigate the VA claim process. As I was retiring, I struggled with my own claim. Information was difficult to find, as was assistance with limited capacity and hours for the large military community in and around Fort Bragg. Despite being a senior officer, it took significant support, advice, and research for me to successfully navigate the system. Unfortunately, I am the exception and not the norm. That is why we founded Veterans Guardian. The VA disability process is a difficult system to navigate, resulting in many veterans not receiving their earned benefits. I am proud of the work my company does to assist veterans with this process. My staff is over 85% veterans, spouses of veterans, and spouses of active duty. We have been recognized with numerous awards as a veteran-owned and operated company, and most recently named the Military Family Brands Company of the Year. We support more than 60 national and local charities, including support to local chapters of many of the organizations that are here today. Our mission is to ensure veterans receive the benefits they are legally, ethically, and medically eligible for due to their service to the nation. I am proud of the work we do to offer a transparent, effective, and efficient option. We are a complementary capability to the other services that are available. We inform every veteran that there are free options available and connect them directly to these services if they choose. We are transparent that we are not accredited, and our clients acknowledge this when they sign our Your Claim, Your Choice affidavit, which was included in my written submission. Our veterans are choosing to utilize our services from a position of knowledge. 70% of our clients come to us after having used the free services available. Veterans are not unaware of the free services and are coming to Veterans Guardian because, in their words, these free services have failed to meet their needs. Contrary to common belief, the current system is not meeting the needs of veterans. Veterans need more options for assistance, not less. Veterans should be able to pursue their claims in the manner that best serves them with the full knowledge of their options. Veterans make an informed choice to use our services for many reasons: easy access and responsiveness, experience and knowledge, ability to help develop medical and lay evidence, and our competence in developing secondary conditions. I am proud that we have assisted over 50,000 veterans to date with over a 90% success rate. We are transparent about who we are and who we are not. We do not aggressively solicit the veteran. We do not have doctors on our payroll. We do not have automated or international call centers. Our one-time fee structure is wholly aligned with our veteran clients because we only collect a fee if the veteran receives an increase in their rating and compensation. We are veterans helping veterans. My clients tell all of us that my services are needed. And one of the bills we're here to discuss today, the GUARD Act, would deny veterans access to my much-needed services. The GUARD Act would force my business to close our doors, lay off my veteran employees, and leave the veteran with no other option than the VSOs. We believe that the GUARD Act potentially raises constitutional issues as it limits the First Amendment rights of the veterans who wish to work with consultants as well as the rights of the consultants themselves. By imposing penalties, including imprisonment, the GUARD Act would take away a veteran's right to choose how they pursue their claim. The fact that veterans are choosing to use our services from a position of knowledge is a proof that the other options are not completely meeting their needs. My veteran clients are telling you and me that the current system is failing them. The GUARD Act limits veterans' choice and means that many veterans will not receive the benefits to which they are entitled. Our veterans deserve more. We continue to be strong supporters of accreditation reform. We support congressional oversight. We support reasonable fee caps. We support an enhanced accreditation process to ensure quality private companies can become accredited and provide veterans more options to navigate the system, not less. We support the intentions of the GUARD Act. However, we believe the execution is not meeting the needs of veterans. We encourage Congress to pass holistic reforms, such as legislation that General Bergman is leading, that allows companies like Veterans Guardian to become accredited. Such reforms provide veterans with the widest range of options to help them pursue their claim at any step of the process. This increases VA oversight of accredited agents, provides for regular audits of claims agents, establishes more detailed standards of conduct, and provides VA with the enforcement tools necessary to pursue bad actors. Our goal should be to expand options for veterans, not restrict them. Veterans should have the freedom to make an informed decision on how they want to pursue their claims. In conclusion, I look forward to continuing to work with you and your staff to address the issues that veterans face and to responsibly serve veterans who have dedicated themselves to the service of our nation, and I look forward to your questions.
Thank you, Colonel. I now recognize myself for 5 minutes. Ms. Keenan, is it the VFW stance that no other corporation or company out assisting veterans in their claims or credit are worthwhile?
Thank you for the question, Chairman. So we believe that anyone who is assisting veterans with their claims should be accredited, that they should go through VA's rigorous process of background checks and training so that they are prepared to give veterans the best assistance possible.
It seems like, and I hate to, we probably shouldn't have set you two next to each other, but it seems like the Colonel's agreeing with that wholeheartedly. So I think my question is, and it's a veteran-owned company. Now, in the absence of proper assistance for our veterans, organizations like the Colonel's is stood up. And in the absence of proper assistance through the VA, the VFW steps in. Now, given that we've just come out of a 20-year war and the amount of individuals leaving the military will most likely scuttle the VA as far as intake comes, if I had to guess. And as hard as the VA is trying, it seems feasible that organizations such as the Colonel's, such as the VFW, might make it easier for the VA to process all these claims and keep our veterans safe. Would you agree or disagree with that statement?
So as long as a veteran is receiving accredited representation and that their claims are being presented in the most complete capacity initially from the get-go, VA will be able to process those claims in the quickest manner that they can. So VA has their own processing time, and no matter of more claims or less claims is going to change that. So the VFW and other organizations that have accredited representatives, we receive up-to-date training as the laws are changing in order to help veterans file their claims accurately as possible, and we believe that's going to help VA process them as quickly as possible.
So if companies and organizations receive the accreditations by, with, and through the VA, the VFW would support that?
If a company is able to be accredited or their individuals are able to be accredited, then they're part of the VA oversight, and the VFW would support that.
Okay, thank you. Mr. Learman, prior to your current position, you represented veterans before the Board of Veterans Appeals for many years. In your experience, what contributes to the delayed decisions at the board, and how would H.R. 1378, the Veterans Appeal Backlog Improvement Act, help address some of these issues?
Thank you, Mr. Chairman. In order to really effectively answer that, there are multiple reasons why an appeal may languish at the Board of Veterans Appeals, and I think you could even look all the way back to how it's developed by a VA regional office before it even gets to the Board of Veterans Appeals. But also during my time there, I saw a large amount of turnover between attorneys. An attorney I may have known and worked with last year has been gone for 2 years. So they're losing institutional knowledge. They are going through a lot of different attorneys very quickly, to where if we were able to provide a pilot program like this, where we're getting quality attorneys in soon, we're going to retain them at the Board of Veterans Appeals and eventually get a better outcome and a quicker decision, hopefully. But again, the reason that some decisions languish have to do with VA regulatory provisions, law changes, and even the court that can delay anything pending at the Board of Veterans Appeals. But well-trained, brought-in attorneys can help alleviate a lot of that pressure on the judge.
I don't know if anybody's ever asked this question before, but would it be advantageous for this committee to hear from the Board of Appeals exactly how to streamline that process?
Absolutely. I think to hear from those working at the board, the judges and the attorneys, or even the director, about some of the problems they're facing outlined directly would, yes, definitely be a benefit to determine how to attack it in another direction as well.
Okay, thank you. Colonel, I believe we need to find a balance between protecting veterans from predatory actors while ensuring veterans have choice over their representation in the VA. Why does Veterans Guardian believe veterans should have the option of paid representation prior to the appeal stage?
Providing veterans with more options and freedom of choice while providing the guardrails and oversight to protect veterans from predatory actors and predatory practices. We believe that more options are better for veterans, not less. We believe that veterans should have the freedom to make that choice from a position of knowledge, and that anything that we can do to increase the access to good advice for veterans is a positive.
Thank you, sir. Mr. Pappas.
Thank you, Mr. Chairman. Mr. Learman, maybe I could start with you, because I know that sometimes we hear the argument that the VSO community doesn't have the capacity to meet the new claims work that's been brought on by the PACT Act and other changes to the law, so that we're going to need to lean on for-profit companies to fill in the gap. I'm wondering if you can detail what DAV and perhaps some of the other VSOs represented here are doing to bolster capacity and recruit new service officers to meet this demand.
Thank you, Ranking Member. DAV has a training program. We have professional members, and to this day, we probably have about 4,000 certified and accredited service officers across the country, to include our volunteers and county veteran service officers. DAV also helps to accredit them around the nation as well. And if you look at the General Counsel's number of accredited agents or advocates out there, there's thousands upon thousands of them that are currently available. So while we continue to train and provide more opportunities and assist CVSOs, we also know that there are thousands of people available that are accredited that may not be utilized because they believe that if you pay for something, that means you're going to get a guarantee.
And Mr. Montreal, many of the unaccredited private sector actors call themselves claims consultants, offer pre-filing consultation in order to rationalize their non-adherence to the law. So that is, they're arguing that because they don't actually hit the send button on the veteran's application, they aren't actually assisting in this preparation. So in your opinion, is there any difference between so-called pre-filing consultations and claims preparation?
No, sir, I think they're exactly the same thing. And quite frankly, it's more problematic when we look at some of the practices that claims consulting companies are engaging in because of a lack of access to VA systems because they're not accredited. There's been instances of individuals requesting a veteran's e-benefits password and access to confidential information that results in their medical information and other forms of information being unsecure because they don't have access to VBMS. So, you know, I don't think there is any difference between the two things, but the claims consultants, the structure incentivizes practices that are unsafe for veterans.
You mentioned 400% to 600% of a monthly increase, perhaps, that a veteran would be on the hook for to pay to some of these claims agents. What does your organization charge a veteran?
We charge $0.
And that's consistent across the VSOs, correct?
Yes.
So, Ms. Keenan, you talked a little bit about this, just the process of your service officers, what they undertake to become accredited. You stress the need for everyone to be under the umbrella of accreditation to provide for some standards and oversights, and I couldn't agree with you more. There's some vetting of the character of these service officers, and accreditation isn't just some arbitrary designation where a volunteer is showing up at your door or you're hearing from an organization one day who wants to assist a veteran. So can you elaborate on this process a bit and whether or not this is a hurdle for more people to pursue to be able to assist our veterans?
Thank you for the question. I mean, we see accreditation as the critical aspect of protecting veterans when it comes to filing their claims. The VFW accredits nearly 2,000 veteran service officers, and so we have gone through that accreditation process, and so we find it necessary. It may seem burdensome, but it is accomplishable in a few months. We're happy to work with VA on understanding if they need more resources in order to process accreditation requests more quickly, but the process is there to be rigorous and to really vet those who are going to be assisting veterans with their claims to provide the best information that they can possible.
Well, thanks for that response. I thank you all for your testimony here today. I think there are a number of critical issues that have come out of this conversation with respect to the Guard VA Benefits Act and a number of other bills. So we thank you for that commitment. Look forward to working with you all. I yield back.
Thank you, Ranking Member Pappas. Congressman Crane, you're recognized for 5 minutes.
Thank you, Mr. Chairman. I appreciate it. Thank you guys for coming today. My first question is for Colonel Taylor down there. Sir, how much do you guys typically charge? Like what percentage per initial claim do you guys typically charge?
Thank you for that question, Congressman. We believe and we maintain a very simple upfront pricing model and fee structure. First of all, I'd like to highlight that we work strictly on a contingent basis. So if the veteran does not get an increase in both their rating and their compensation, there's no fee.
Great.
And we do not collect anything.
What's the percentage, sir?
Our fee is 5 months of the increase. So if a veteran were come to us at a certain amount, the difference between where they are after having our assistance, their fee is 5 times that difference. We offer 3 payment plans. They can pay that in a lump sum with a 10% discount. They can pay it out over 5 months, 10 months. There's no interest or fees for payment plans, and it is completely voluntary. We have no access to their bank accounts.
Thank you, sir. You know, as a veteran myself and also a small business owner, I quite frankly get frustrated with the VA and bureaucracy often. And so I often look for private companies to work with, just because they don't have to deal with a lot of the bureaucratic red tape. And I know a lot of other veterans feel the same way. Now, some don't. Some don't have the money to do that. Some have all the time in the world. But I can tell you that there are issues with people dealing with the bureaucracy. It's frustrating at times. It takes a long time. So my next question to you, Ms. Keenan, is why do you have such an issue with a veteran like myself who wants to go out there and utilize a consultant, even if I'm willing to pay the extra money? And I know you talk about accreditation and you want veterans, you don't want veterans to get harm, and I understand that. But that's inherent in the free market system. So why do you have a problem with a veteran like me who is willing to go pay a consultant to help me navigate the system and speed me through it so I can just get the outcome that I want?
Thank you for that question. So there are paid options for veterans currently within the accreditation system. So a veteran can pay an attorney or an agent that is accredited for their services. Those payments, those services are capped as how much they can charge, but there are paid options available currently to veterans. Our main concern is how do you rein in the really predatory actors?
Right.
If there are no penalties, there's really no way for VA to even track them or penalize them.
No, I appreciate that. Thank you. Colonel, have you been able to get accredited?
Company to become accredited, and the restrictions on what we can charge a fee for would not allow me to continue with my business model. When I look at a veteran, I want to look at them holistically, and I want to look at things that they should have claimed that they haven't. I want to look at secondary conditions, and I want to look at things that they've claimed that we feel they're either underrated for or been denied for. We believe that we should look at a veteran holistically and take care of all of that at the same time. If I become accredited, I can only assist with the third pillar for a fee, which
Real quick,
is appeals.
Colonel, do you tell the veterans that you're working with that there are other options, that if they're willing to wait and deal with the VA, they can get this done for free?
Without understanding their options, and particularly the fact that there are free services available. Every one of my clients signs a single one-page affidavit called the Your Claim, Your Choice that has 5 simple bullet statements on it that acknowledge that there are free services available and where to find them, that they can be successful using those free services, that they can be successful on their own, and that they're choosing to use me right now as an unaccredited agent, and that they understand my fee structure. My dream is that we can change that and I can become an accredited agent and operate within the system with the guardrails and with the protections to protect veterans from predatory actors and practices.
Thank you. It's one of these things. I'm always going to err on the side of free will, the free market system. I do appreciate what you guys are trying to do as far as protect, veterans, but at the same time, I hope you acknowledge why the free market system is so cherished in this country. It's so integral to who we are. And yeah, sometimes there are bad outcomes in the free market system, but a lot of Americans and citizens are tired of so much bureaucracy slowing everything down, not providing options for them. And that's what this town does a lot of, quite honestly. It develops so many levels of bureaucracy that it gets hard to get anything done. And to Colonel's point earlier, if the bureaucracy was doing such a great job, he wouldn't be in business. I yield back my time. Thank you.
Thank you, Mr. Crane. Congressman McGarvey, you're recognized for 5 minutes, sir.
Thank you, Mr. Chairman. Thank you all very much for your testimony. I am proud to be a co-lead of a bill with my colleague, Mr. Subcommittee, the Veterans Appeals Backlog Improvement Act. And this bill would create a new pipeline program for entry-level attorneys in addition to mandating a report on telehearings at the BVA. We've seen staggering, unacceptable backlogs during the appeals process in veterans trying to access their earned benefits. This bill is one step closer to helping mitigate those issues. Mr. Learman, if you don't mind, just tell us a little bit about what this bill would mean for your members.
Well, I think most of it, and thank you for the question, is that it's going to add more resources to the judges, more resources and more attorneys. Within the last year or so, they have added additional veterans law judges at the board, but I think the piece we often forget about is that does include their support mechanisms, which a lot of times that'll include at least 10 additional employees to include new attorneys. So when we're increasing that, we're increasing their support. I believe recently we were informed by the board that right now there are around only 5 people that are currently available to the veterans law judge, to where previously and most effectively would be 10 to include new attorneys. So we think what this will do is give a viable option for new attorneys, support process to the judges, and quicker decisions.
Thank you, I appreciate that. The backlog is unacceptable. We can do something about it. And again, this is to clear the backlog of veterans who are trying to access the benefits they have earned. I appreciate that. Mr. Chairman, I yield back.
Thank you, Mr. McCarthy. Mr. Bergman, you are now recognized for 5 minutes, sir.
Thank you. Let's get right to the meat of it. Lieutenant Colonel Taylor, what metrics or model is used to justify your company's fee for your service?
Congressman, that's a great question. As a private company operating in a free market, my clients are justifying my fees. We have a simple, straightforward contingent fee model that is only charged if a veteran has a successful outcome. That fee model is clearly communicated to the veteran before they make a choice to use my services. And the veteran can make the choice on whether or not my fee is justified. And some of the statistics, 50% of my clients are coming as referrals from former clients who saw value in the services and the fee that we're charging. We have a less than 2% failure to pay rate, and every payment that I receive is voluntary from the veteran. So my clients simply are justifying our fee model, and this allows us as a business to hire and train expert staff, to maintain HIPAA-compliant, secure IT servers, because we're dealing with extremely sensitive information from these veterans, and maintain a dedicated client support team providing first-class service to our veterans.
Thank you. And would you support implementing safeguards that would allow businesses like yours that help veterans obtain positive results to continue to operate while preventing and punishing, I mean, really holding bad actors accountable in this space?
Absolutely, Congressman. We have maintained from the beginning that we are in full support of accreditation reform. We are in full support of any model that allows us into the tent, and we invite the oversight. We'd actually like to see accreditation strengthened even further beyond what it is right now. We'd like to see increased audits of all of the accredited agents and how they're performing and the level of service that they're providing, increased oversight of their training programs, and really having those guardrails out there, because I'm not going to sit here today and pretend that there aren't bad actors. I'm not going to sit here today and pretend that there aren't bad practices. But let's put the guardrails in place to protect veterans from those bad actors and from those practices that we don't like, and ensure that well-intentioned, honorable companies, VSOs, agents, and attorneys are providing the widest range of options to help veterans navigate this difficult process.
Thank you. Along those lines, and I know everybody in this room is here for the right reasons. Along those lines, last night, I introduced H.R. 1822, the Preserving Lawful Utilization of Services, or PLUS for Veterans Act of 2023, along with my colleague and fellow veteran Representative Nancy Mace from South Carolina. This bill seeks to strike a balance by restoring penalties for non-accredited agents and attorneys that assist veterans with their claims, improving the accreditation system to allow businesses like Veterans Guardian and others to continue to do their good work, and adding safeguards to prevent and punish bad actors that seek to take advantage of veterans and ultimately their families as well. And I would just like, you know, in listening to the entire hearing today, and I see that our folks from the last panel are still in the audience, because this ties in to the future, because what we're dealing with are current practices and policies. We're trying to implement new ones that enable us to move forward positively. And I guarantee you there's probably a young person either here in the room or listening to this, who's probably going to say, I wonder if I could create an app for that. And how would the VA, and this is just thinking about the future, how would the VA accredit such an app? And with that, I yield back.
Thank you, Mr. Bergman. Ranking Member Pappas, any closing remarks?
Sure. Thank you very much, Mr. Chairman. Thank you to our last panel, and I want to thank all the members for a productive conversation on the bills before us today. Our witnesses provided insight, and we look forward to staying in touch as we move forward. Having heard once again today about the issue around unaccredited disability claims consultants who continue to target our veterans for financial gain, I couldn't be even more adamant that our bill, H.R. 1139, the Guard VA Benefits Act, is necessary. It's a meaningful step towards stopping these bad actors by reinstating criminal penalties for their actions. We heard today from VA that about 40% of complaints come from or about non-accredited actors, and there is little to nothing that is being done about it. So we need some teeth in the law, and I look forward to working with my colleagues on a solution that will help address this situation and ensure that our veterans can get their claims processed in a timely fashion and get an outcome that is positive and beneficial to them. I want to commend the continued support of VA and our VSOs in assisting the veterans community and their commitment to ensuring that veterans receive the care and benefits that they have earned without profit motive being a driving force behind those actions. Veterans and their families should have peace of mind when filing a claim for VA benefits. And for those who have served our country, I commit to you that there is nothing more, there are still more that can and should and will be done to hold those individuals and businesses accountable. So I want to thank our panelists again for their remarks and commend my colleagues for their thoughtful contributions to this conversation. I yield back, Mr. Chairman.
Thank you, Ranking Member Pappas. I look forward to working through the issues with my department and my colleagues on this subcommittee. As I've said before, the complete written statements of today's witnesses will be entered into the hearing record. I ask for unanimous consent that the statement for the record submitted from the following members and/or organizations be entered into the hearing record. Representative Michael Waltz from Florida, the Court of Appeals for Veterans Claims, Gold Star Wives, National Organizations of Veterans Advocates, and Tragedy Assistance Program for Survivors. Hearing no objections, so ordered. I ask unanimous consent that all members have 5 legislative days to revise and extend their remarks and exclude extraneous material. No objections. And I thank the members and the witnesses for their attendance and participation today. Ladies and gentlemen, thank you so much for taking your time. VA representation, God bless each and every one of you. And we look forward to my colleagues on the right and the left with this. We look forward to figuring this out so our veterans are safe. God bless. Adjourned.